Welcome to our deep dive into insolvency in Australian corporate law.
Yeah.
We're going to be looking at what happens when a company is in financial distress, and we'll be looking at this from various sources.
Okay.
We've got academic texts, legislation like the Corporations Act, and real-world examples.
Great.
So by the end of this deep dive, you will understand the key processes involved, who the players are, and what's at stake for everybody, from the directors to the creditors.
Sounds good.
Let's kick things off by looking at a recent example.
Sure.
The tech company Medici went from voluntary administration to liquidation, and that's what we're going to be unpacking in this deep dive.
That's a really interesting case and a good example of how complex these situations can be.
Yeah.
So where should we start?
Well, I think we should probably start by defining insolvency.
Okay, good point.
What is it?
So the legal definition of insolvency in Australia is found in Section 95A of the Corporations Act.
Okay.
And it says that a company is insolvent when it can't pay its debts, as and when they become due and payable.
All right, so it's not just about having enough assets to cover the liabilities.
Exactly.
It's about that cash flow.
Absolutely, it's a cash flow issue.
Okay.
A company might have plenty of assets, but if they can't convert those assets into cash quickly enough to pay their bills when they're due,
Yeah.
then they're considered insolvent.
Okay, so what are some of the signs that a company might be heading towards insolvency?
Well, there are a few common indicators.
Yeah.
Things like continuing losses. If a company is consistently losing money, that's a red flag.
Yeah, makes sense.
Also, consistently overdue taxes. If a company is struggling to pay its taxes on time, that could be a sign of deeper financial problems.
Yeah.
Another thing to look out for is strained relationships with banks.
Okay.
If a company is having trouble getting loans or maintaining its existing credit lines, that's another warning sign.
Yeah.
And of course, difficulty securing new financing. If a company can't raise capital from investors or lenders, that's often a sign that the market has lost confidence in its ability to repay its debts.
Okay, so it's all about managing that cash flow.
Exactly.
Right. So now that we've kind of got an idea of what insolvency is, let's talk about the legal processes that happen when a company becomes insolvent.
All right.
What happens?
So the most heavily regulated process associated with insolvent companies is winding up,
Okay.
which is also known as liquidation.
Right.
And this is governed by Chapter 5 of the Corporations Act, which is titled External Administration.
Okay.
Now, winding up can happen in two ways:
Okay.
compulsory liquidation and voluntary liquidation.
So for this deep dive, we're going to focus on compulsory liquidation.
Yeah, I think that's a good place to start.
Okay. So what triggers compulsory liquidation, and what does it actually look like?
Okay, so a winding up order can be initiated by various parties.
Right.
It could be the company itself,
Oh.
or a creditor who hasn't been paid, a director, a shareholder, or even ASIC.
ASIC. Wow. Yeah.
Yeah, so once an application is made to the court assesses the company's solvency,
Right.
and they often rely on Section 459C of the Corporations Act,
Okay.
which outlines certain presumptions of insolvency based on specific events,
Okay. Like what?
like failing to comply with a statutory demand for payment.
So it's not enough to just be in debt. You have to demonstrate that you can't pay your debts.
Exactly.
Okay, so let's say a company receives a winding up order.
Yeah.
What happens next?
Well, once that order is issued, control of the company shifts from the directors to a court-appointed liquidator.
Okay. And what does the liquidator do?
So the liquidator's primary duty is to wind up the company's affairs,
Okay.
which means they're going to realize the company's assets,
Right.
and then they're going to distribute the proceeds to creditors
Okay.
in a specific order outlined in the Corporations Act.
So the company essentially stops operating.
Yeah, that's right.
Okay, so let's talk about that order of distribution.
Okay.
Who gets paid first?
So first in line are the costs associated with the liquidation process itself.
Okay, so like the cost of paying the liquidator.
Yeah, exactly. You've got to pay the people who are winding things up.
Yeah, of course.
Then next in line are employee claims.
Right, so that's like unpaid wages.
Yeah, unpaid wages, accrued leave, entitlements, superannuation contributions, any outstanding employee benefits.
Okay, so the employees are pretty high up there in the pecking order.
Yes, employee entitlements are given a high priority.
Okay.
And then after that, it's generally the secured creditors.
Right, those are the ones who have some kind of security over the company's assets.
Exactly. So they get paid out of the proceeds from the sale of those specific assets.
So if you're a creditor, it's better to be a secured creditor than an unsecured creditor.
Absolutely. Secured creditors are in a much stronger position
Okay.
because their claims are backed by specific assets.
So where do unsecured creditors fit into all of this?
Well, unsecured creditors are kind of at the bottom of the pile,
Well, it
unfortunately.
doesn't sound good.
Yeah, they're paid after the secured creditors and the priority creditors.
And how does that work? Do they all get paid the same amount?
So the principle of pari passu applies to unsecured creditors.
Pari passu.
It's a fancy Latin term that basically means they're treated equally,
Right.
so they receive a proportional share of whatever assets are left over.
Okay. But if there's not much left,
Yeah, often there's not much left for unsecured creditors.
so they might not get anything.
Exactly. They often end up receiving very little, if anything at all.
That's a pretty big risk for unsecured creditors.
It is, and it's important for businesses to understand the risks associated with lending money without any security.
Yeah, for sure.
Now, before we move on, I do want to mention that there are alternatives to winding up.
Oh, really? Tell me more.
Yeah, Australian corporate law has shifted away from simply shutting down companies.
Okay.
There's a real focus on rescue now.
Rescue.
Yeah, trying to
Yeah.
save viable businesses.
Okay, that makes sense.
So the Corporations Act actually offers several alternatives to winding up.
That's good news.
Yeah, and these alternatives have different processes and different potential outcomes.
So what are these alternatives to winding up?
Well, the three main ones are schemes of arrangement,
Okay.
voluntary administration, and more recently, restructuring.
So companies have options.
That's right. They're not automatically doomed if they hit financial trouble.
Okay, so let's start with schemes of arrangement.
Okay, so a scheme of arrangement
Yeah.
is essentially an agreement
Uh-huh.
between a company and its creditors.
Okay.
That's approved by the court.
Right.
It allows the company to compromise or restructure its debts
Okay.
and hopefully continue operating.
So it's a way to kind of renegotiate the terms of the debt.
Exactly.
Right.
It can be a really flexible tool, but it can also be quite complex and expensive.
Right, because you got to go through the courts and get all the creditors to agree.
Yeah, exactly. There are court applications, creditor meetings, a formal voting process.
Sounds like a lot of paperwork,
It can be, but it can be a really effective way to save a company.
especially for larger companies.
Yeah, especially for larger, more complex companies that need a tailored solution.
Okay, so what about voluntary administration?
So VA is a bit of a different beast.
Okay.
It was introduced in 1992.
Right.
And it provides a potentially faster and cheaper alternative to a scheme of arrangement.
Okay, I like the sound of that.
Yeah, VA aims to give a struggling company some breathing room
Okay.
to assess its options and potentially restructure its debts.
Mm-hmm.
And this all happens under the guidance of an independent administrator.
Okay, so who appoints this administrator?
Usually it's the company's directors who appoint the administrator,
Okay.
but a secured creditor can also do it. Or even the court in some cases.
All right. And once the administrator is appointed, what happens next?
So the administrator steps in and takes control of the company's affairs,
Oh.
and they start investigating the company's financial position.
So it's like hitting the pause button on the company's operations.
Yeah, exactly. It gives everyone a chance to step back and figure out what's going on.
Right. So what are the next steps in the voluntary administration process?
Well, the administrator then has to convene 2 meetings with the company's creditors.
Okay. And what happens at these meetings?
So the first meeting is held within 8 business days of the administrator's appointment.
Right.
And at this meeting, creditors can actually decide to replace the administrator if they want.
Oh, okay.
And they can also appoint a committee of inspection.
What's a committee of inspection?
It's basically a group of creditors
Mm-hmm.
who oversee the administrator and the VA process.
Okay. So the creditors have a lot of power in this process.
Yeah, they definitely have a say.
And what about the second meeting?
The second meeting is the big one,
Okay. Why is that?
because that's where the creditors vote on what happens next.
Okay. And what are the options?
Well, there are 3 main options.
Right.
They can vote to execute a deed of company arrangement.
Okay. What's that?
We'll get to that in a minute. They can also vote to put the company into liquidation.
Right back to square one.
Essentially, yeah.
And what's the third option?
The third option is to end the administration and hand control back to the directors.
Okay. So let's go back to that deed of company arrangement, or DOCA.
Yeah, so a DOCA,
Yeah.
it's basically a legally binding agreement
Okay.
between the company and its creditors.
Right.
That outlines how the company's debts will be restructured
Okay.
and how the company will be managed going forward.
So it's like a roadmap for the company's recovery.
Exactly.
Okay.
It might involve things like asset sales debt, forgiveness, new investment.
So if the creditors vote for a DOCA, the company gets a second chance.
Yeah, it does.
But what if they vote for liquidation?
Well, if they vote for liquidation, then the company is wound up.
Right.
Just like we talked about earlier.
Okay, and what about that third option, ending the administration?
Ending the administration is less common,
Okay.
and it usually only happens if the company is actually solvent.
All right, so it doesn't need external administration anymore.
Exactly.
Okay, so VA can be a really successful process,
Yeah, it can.
but it's not always a guaranteed happy ending.
That's true.
Okay, so before we wrap up this part of our deep dive,
Yeah.
I want to talk about one more aspect of VA,
Okay.
the moratorium.
Ah, yes, the moratorium.
What is it?
So the moratorium is a really important part of the VA process.
Okay.
It basically puts a temporary freeze on most legal actions against the company
Okay.
while the company is under administration.
So it gives the companies some breathing room to
Exactly.
sort things out without being constantly harassed by creditors.
Yeah, that's the idea.
So are there any exceptions to this moratorium?
Yes, there are a few exceptions.
Okay, like what?
For example, secured creditors with security over all or substantially all of the company's assets.
Yeah.
They can sometimes enforce their security outside of the VA process.
Okay.
There are also some exceptions for perishable goods
Hmm.
and for situations where enforcement action had already commenced before the administration began.
Right, so the moratorium isn't a complete shield,
It's not.
but it does provide a level of protection for the company.
Yeah, it gives them a chance to catch their breath and work on a plan.
Okay, so we've covered a lot in this first part.
We have.
We've looked at the definition of insolvency, the process of winding up,
Yeah.
and the potential lifeline offered by VA.
It's a complex area of law, but it's important to understand.
For sure.
Especially if you're running a business.
Absolutely. Well, we'll pick up from here in part 2.
Sounds good. I'm looking forward to it.
Me too. Welcome back to our deep dive into Australian insolvency law.
Glad to be back.
In this second part, we're going to delve into the world of secured creditors
Okay.
and their significant role in insolvency proceedings.
Right. So secured creditors,
Yeah.
they hold a very unique position
Okay.
because they have security interests in specific company assets.
Right. So their debt is backed by some kind of collateral.
Exactly. And this security interest,
Yeah.
it gives them priority access to those assets if the company can't pay its debts.
Okay. So it's like a safety net for the secured creditors.
Exactly. They're in a much stronger position
Okay.
than unsecured creditors.
So how do secured creditors actually enforce their claims?
Well, one option is to appoint a receiver.
Okay, a receiver.
Yeah, and a receiver is defined in Part 5.2 of the Corporations Act,
Mm-hmm.
and it's usually an insolvency practitioner
Okay.
who takes control of the secured assets,
Right.
sells them,
Yeah.
and then uses the proceeds to repay the secured debt.
So it's like a direct route for the secured creditor to get their money back.
Pretty much.
So does this mean secured creditors always get all of their money back?
Well, not necessarily.
Okay, why not?
Even though they have priority over those secured assets,
Yeah.
sometimes the sale proceeds might not cover the whole debt.
Right, especially if the asset has lost value.
Exactly.
Okay.
And also, there are certain priority claims,
Like what?
like employee entitlement.
Right.
Those might actually take precedence over the secured creditor's claim.
Even if the secured creditor has security over that specific asset.
It depends on the type of security.
Oh, okay.
But yeah, in some cases, employee entitlements will actually come first.
Wow, so even if you're a secured creditor, it's not a guaranteed 100% recovery.
No, it's not.
Interesting. Okay, so what happens if the sale of the secured assets actually brings in more money than what the secured creditor is owed?
So if there's a surplus after the secured debt and the costs are paid,
Yeah.
that surplus usually goes back to the company
Oh,
or
weird.
to the administrator if the company is under administration.
So it's not just like the secured creditor gets to pocket all the extra cash.
No, it gets distributed fairly.
Okay, good to know.
Yeah.
All right, so I want to shift gears a bit now
Okay.
and talk about voidable transactions,
Right.
which we touched on briefly in the first part.
Yeah, voidable transactions are a key part of insolvency law.
Okay, and how do they work?
So essentially, they give the liquidator or administrator the power to investigate and potentially overturn certain transactions
Okay.
that happened before the company became insolvent.
So transactions that might have been dodgy?
Yeah, transactions that might have been done to disadvantage the creditors.
Right, to try to hide assets or something like that.
Exactly.
Okay, so what kind of transactions are we talking about here?
Well, a classic example is an uncommercial transaction.
Okay, uncommercial transaction.
So let's say a company is on the verge of insolvency
Mm-hmm.
and it sells a valuable asset to one of its directors.
Yeah.
but at a price that's way below market value.
Right. So the director gets a sweet deal.
Yeah, and the creditors lose out.
Okay, that makes sense. What else?
Another common example is an unfair preference.
Okay.
This is where a company might preferentially repay a loan to a related party,
Okay.
like a family member or another company in the same group,
Mm-hmm.
while ignoring other creditors who have similar claims.
Right, so they're playing favorites.
Exactly.
Okay, so how do you actually determine if a transaction is voidable?
Well, there are two main factors to consider.
Right.
The first is the company's solvency at the time of the transaction.
So was the company already insolvent when they did the deal?
Exactly.
No.
Or did the transaction actually push them into insolvency?
Right, so it's all about timing.
Yeah, timing is crucial.
Yeah, okay, what's the other factor?
The other factor is the time frame. So there are specific look-back periods.
Look-back periods.
Yeah, that are outlined in Part 5.7b of the Corporations Act.
Okay.
So for uncommercial transactions, the look-back period is generally 2 years
2 years, okay.
from the relation back day.
Relation back day, what's that?
It's usually the date the winding up application was filed.
Okay.
And for unfair preferences,
Yeah.
the look-back period is generally 6 months.
So the liquidator or administrator has a limited window of time
That's right.
to claw back those assets.
Exactly.
Okay, so it's a pretty complex area.
It is.
So it's an important one.
Absolutely. It's all about protecting the interests of the creditors.
Right. Okay, so moving on.
Yeah.
I want to talk about another alternative to winding up
Okay.
that we haven't really discussed yet.
All right.
Small business restructuring.
Right. So small business restructuring.
Yeah.
This is a relatively new process.
Okay.
It was introduced in 2021,
Right.
and it's designed specifically for smaller companies.
Okay, so what's the difference between small business restructuring and voluntary administration?
Well, the main difference is that in small business restructuring, the directors actually stay in control of the company.
Oh, okay, so they don't hand over the reins to an administrator?
No, they don't.
That's interesting.
Yeah, it gives them a chance to be more hands-on
Okay.
in the restructuring process.
So how does it work?
Well, it starts with the appointment of a restructuring practitioner.
Okay, so that's kind of like the administrator in VA.
Yeah, you could think of it that way.
Okay.
And this practitioner will assess the company's financial position
Mm-hmm.
and then work with the directors to develop a restructuring plan.
Because it's a collaborative effort. Exactly.
And what does this restructuring plan look like?
It basically outlines how the company is going to manage its debts
Okay.
and its operations going forward.
All right, and then what happens?
Well, the plan is then put to the creditors for approval.
Okay, and if the creditors approve it,
If the creditors give it the thumbs up,
yeah.
then the company enters a restructuring period.
Okay, and what happens during that period?
So during that period, the company implements the plan.
Right, so they try to stabilize their operations,
Exactly.
renegotiate contracts, get back on track.
Yeah, basically.
Okay, and what if the creditors don't approve the plan?
Well, if the plan gets rejected,
Yeah,
then the company might have to consider other options.
like VA or liquidation.
Yeah, exactly.
Okay, so small business restructuring, it's not a guaranteed solution,
It's not.
but it's a good option for smaller companies.
It gives them a fighting chance.
Okay, well, we've covered a lot of ground in this part.
We have.
Secured creditors, voidable transactions, small business restructuring.
It's a lot to take in. It is.
Right, yeah.
But I think it's really important for people to understand these concepts,
I agree.
especially if they're involved in business in any way.
Absolutely. Well, let's take a break here,
Okay.
and we'll come back for the final part of our deck dive.
Where we'll be looking at the role of professional bodies in the insolvency landscape.
Sounds good.
See you soon. Welcome back to our deep dive into Australian insolvency law.
It's been a fascinating journey so far.
It has, in this final part, we're going to look at the role of professional bodies in the insolvency landscape.
Okay, so professional bodies, they play a huge role in upholding ethical standards, providing guidance and support to practitioners, and advocating for best practices in the industry.
So they're kind of like the guardians of integrity in this whole process.
Exactly.
Okay, so which professional bodies are the most prominent in Australia when it comes to insolvency?
Well, one of the big ones is the Australian Restructuring, Insolvency, and Turnaround Association,
Okay.
or RETA.
Or RETA, all right.
And they represent insolvency practitioners, restructuring advisors, and other professionals involved in turnaround and insolvency.
So they set the standards for everyone working in this field.
Yeah, pretty much.
Okay, so how do they make sure that their members are actually upholding these standards?
So ORDITA members, they have to abide by a code of professional conduct.
A code of conduct.
Yeah, and this code,
Mm-hmm.
it outlines their responsibilities to clients, creditors, the courts, and the wider community.
So it's all about ethical behavior.
Exactly. Things like integrity, objectivity, confidentiality, competence.
Right. So it's not just about knowing the law. It's
Yeah,
also about acting ethically.
absolutely.
Okay. So besides setting standards, what else does ARETA do?
Well, they also provide a lot of education and training for their members.
Okay.
They offer courses, certifications, resources.
So they're keeping everyone up to date?
Yeah, with the latest legal developments, industry, best practices, all that good stuff.
So ARETA is really a driving force for professionalism in the insolvency industry. Are there any other professional bodies that play a significant role?
Yeah, so another one is the Institute of Chartered Accountants in Australia.
CAANZ.
That's the one.
Okay, and what do they do?
So CAANZ, they have a broader focus,
Mm-hmm.
but their code of ethics,
Yeah.
it applies to all of their members, including those working in insolvency.
Okay, so even though they're not specifically focused on insolvency,
Yeah.
they still have a big impact.
They do, because insolvency often involves really complex financial information.
Right.
So it's crucial that the accountants involved are acting ethically and competently.
Absolutely. Okay, so we've talked about professional bodies.
Yeah.
Now, what about ASIC?
Right. ASIC, the Australian Securities and Investments Commission,
That's the one.
they're the regulatory watchdog.
Okay, so they keep an eye on everyone.
Yeah, they monitor insolvency practitioners, they investigate any potential breaches of the law, and they can take enforcement action against anyone who's doing the wrong thing.
So they're the ones with the big stick.
Cre-
Okay, what about the creditors?
Right, the creditors.
Yeah, they're the ones who are owed money.
Yeah, they're the ones who are most directly affected by insolvency.
So what rights do they have?
Well, they have a number of important rights.
Okay, like what?
One of the key ones is the right to be informed.
Okay.
So the insolvency practitioners have to communicate with the creditors regularly,
Okay.
give them updates on the case, explain their options, seek their input on decisions.
So it's all about transparency.
Exactly.
Okay, what else?
Creditors also have the right to vote
Right.
on certain matters,
Okay, like what?
like appointing or removing an insolvency practitioner
Uh-huh.
or approving a deed of company arrangement.
Okay, so they have a voice in the process.
They do. Their vote is usually weighted according to how much money they're owed,
So the bigger the debt, the bigger the say.
basically, right?
Okay, and how does the system protect creditors when it comes to actually getting their money back?
So as we discussed earlier, there is an order of priority for distributing assets in insolvency. Secured creditors, they generally come first.
Yeah.
Then priority creditors, like employees,
Mm-hmm.
and then general unsecured creditors.
Right. But there are other things that can affect how much a creditor ultimately receives.
Yeah, like voidable transactions or restructuring agreements.
So it's not always a straightforward process.
Definitely not.
But the system does aim to ensure that creditors' interests are protected.
It does, and it also tries to give struggling companies a genuine chance to recover.
Right, because sometimes shutting down a company isn't the best solution for anyone.
Exactly. A successful turnaround can actually lead to a better outcome for everyone, including the creditors.
So it's all about finding that balance.
Yeah, finding that sweet spot between protecting creditors and giving companies a second chance.
Well, we've covered a lot in this deep dive into Australian insolvency law.
We have. It's a complex area, but hopefully our listeners now have a better understanding of how it all works.
I hope so.
Thanks for having me.
It's been a pleasure having you, and thank you to our listeners for joining us on this deep